thanks, Tim, for joining us today. It's been a great presentation with our clients, obviously talking about estate planning and the importance of having a will and making sure that it's up to date and that we choose our executor right. So we had some interesting questions come out of it. One of them was, how do we choose the right executor? What would you say are the most important things to think about when you choose an executor?
Look, during the presentation I talked about trust, and that's probably the guiding note to the appointment, because it's very difficult to imagine what the executor is going to have to face during an administration, and to know that the person you trust and the person in your mind is the best place to fulfil that role is probably the guiding note for the appointment. Regularly people talk about, do they have to be a lawyer or do they have to be an accountant? The answer is no. They don't, because regularly most estate administrations are assisted through the advice of the advisor network that often is already in place. So the trust principle is very, very important, but someone also who's prepared to take advice, because as I said, you can't always be sure what's going to come up, and it's best for someone, if something like that does happen, that they're prepared to listen and take advice and make the best decision for the estate.
Perfect. And so what about, how many executors should I have? What would be the optimum sort of?
Oh, look, at a bare minimum would be 2. And quite apart from the benefit that can provide if something happened to one of them, although you would also advocate for some substitute executors as well, having at least 2 ensures that you've got a check and balance already inbuilt into the process. The court can grant to as many as 4 people a grant of probate, but 4 can sometimes be a bit too many, because of the administrative burden that can sometimes then come to bear of passing one document around 4 different times. So it can increase costs, but look, generally speaking, within those parameters is workable, as long as people are aware that the more you have, then can increase that load and sometimes the costs.
Okay, perfect. And we also then talked about obviously enduring powers of attorney and the fact that that's an appointment for while you're still living. Does it have to be the same person who's the enduring power of attorney and the executor? Look,
it doesn't have to be, but what you regularly find is the same considerations for the appointment of the executor under the will are often the same considerations for the person as an attorney. So there's certainly no legal requirement that they be the same people, but often they can be. But again, the trust principle is an important one, and particularly for an attorney, because an attorney will be making decisions during the period you're still alive. So there's, in my view, a very high bar to ensure that they're making the right decisions. You've got to have the right person.
So can I ask, with an enduring power of attorney, what's the thing that you see people do wrong the most, or do poorly as a power of attorney?
Look, there's many things that attorneys don't know.
Yes.
There's some aspects of the law which can be a trap and trip people up who are not seeking to do the wrong thing, but find themselves on the wrong end of some of these issues because they're not aware. And so for an attorney, my advice certainly would be to, if they're in that role, to ensure they understand what their obligations are. And to get on top of that very quickly, because the decisions can sometimes be a lot and big, both financially and significantly from a healthcare point of view. So having an understanding of what your obligations are and your duties are is essential to good decision making.
Perfect. And I guess the last question would be, around that advanced health directive document that isn't talked about very much, but can be a really useful part of estate planning. What are your thoughts around that?
Look, I mentioned in the presentation today that very early on in my career, I used to view it as a bit of a cherry on top document. That was entirely unfair, because although if you don't have one, your attorney, in particular healthcare decisions, will be able to make those decisions and assist the doctors to make it. The Advanced Health Directive will bind and direct your medical practitioners to make decisions in accordance with your wishes. And by virtue of that, it may very well mean that your attorney does not have to make that decision. And that can be equally significant, particularly with such a significant decision which is often incorporated into those documents.
Tim Baumann, thank you very much.
No problem at all.